and I need to read a script for us before we start. So good morning, everybody. Hello, I am Deb Stidham, and I serve as chairperson of the Addiction Counselor Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that's being conducted remotely by conference call and other electronic medium. Jacqueline Lightcap.
Here.
Tina Boyd.
Present.
Lisa Carter.
Present.
Jason Hess. Jason?
You're really quiet.
Oh, sorry. Jason Hess.
Oh, then I guess that's me.
Yes, sorry.
With the uncomfortable silence, I thought it might have been my name.
Shane Hudson. Michael James.
Present.
Dulcinea Rakestraw.
Present.
Donna Shook.
Present.
Justin Spees.
Here.
So I note that the following staff members are also present: David Fye.
Here.
Leslie Allen.
Here.
Ashley Van Buskirk.
Here.
Attorney General Janet Arndt and Lainey Bernard, who are assigned to the board as general counsel, are also present. So next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act does not require the advisory committee to provide public comment or answer questions from individuals. There will be no public comment at the meeting today to ensure adequate time for the items listed on the advisory committee's agenda. Because we're conducting the public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because the emergency declaration that was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns, as the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to the meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the COMA are not suspended. As such, we'll be conducting this meeting pursuant to COMA and KAR 16-20-1 concerning compliance with the COMA during the existing emergency disaster declaration. On February 8th, 2021, we sent notice of the advisory committee meeting to all individuals who had requested notice of the advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at the website. An agenda and other meeting materials were posted to the website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line "Request for the agenda," and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the advisory committee, staff, or presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting shall ensure microphones, phones, and other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the advisory committee votes, and each advisory committee member will vote when their name is called. The chairperson will announce the result of the final vote. The advisory committee lacks the authority to delegate a member of the committee or staff to sign any binding document on behalf of the board, thus no statement or motion will be made. A recording of the meeting will be posted to the board's website. The advisory committee has the following items listed on the agenda: call to order and roll call, approval of minutes from the December 18th, 2020 meeting, advisory committee role and responsibility training, executive session, new business, and then adjournment. The advisory committee agenda includes an executive session. If the advisory committee elects to go into executive session, the advisory committee will follow this process. First, the advisory committee must be in an open meeting before going into an executive session. Then an advisory committee member must make a motion to recess for an executive session that is seconded by another advisory committee member. Each advisory committee member will then vote. A majority of the advisory committee must vote in favor of the motion to exercise an executive session. The chair will announce the result of the vote. The motion must contain a statement of justification for closure and the subject to be discussed pursuant to KSA 75-4319B, and the time and place the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume to the conference call. The complete motion for an executive session will be recorded in the minutes, and members of the advisory committee, you should have received an email yesterday late afternoon with language for an executive session motion. So at the time that the executive session is scheduled on the agenda, if a member of the advisory committee could make a motion using that language, it would be greatly preferred.
Thank you, David. All right. Well, the next item on the agenda is approval of minutes from the December 18th, 2020 meeting. So hopefully you all received that and had a chance to look it over.
This is Dulcinea Rakestraw, and I make the motion to approve the minutes as submitted.
Okay.
This is Jason Hess. I second that motion.
All right. All in favor, say aye.
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 Any
Aye.
opposed? All right, next up is Janet Arndt from the Attorney General's Office is going to provide a training for us. My understanding this goes about 90 minutes. Is that right, Jan?
Hope not to go that long.
Okay.
Kind of depends on how many questions we have and so forth, but we'll try to keep it maybe an hour, hour and 15 minutes, something like that. Try to cover as much as I can.
Okay, great. Well, we're ready for you.
Okay, good morning, everyone. My name is Janet Arndt. I am an Assistant Attorney General with the Kansas Attorney General's Office. I've been assigned to the board as their General Counsel since 2011. The board, we typically give training to the board every year. This year, however, the board asked that we also include the advisory committee members because typically they don't get those type of training. However, a lot of what applies to the board also applies to the committee members because you are a subgroup of the board. So that's why you've gotten kind of hooked into this so that I think too, probably going through the training will help you have a better understanding of what the board can and can't do. So as you know, as you're an advisory committee, that may help you kind of frame the what you do and what you recommend to the board to do. So a little bit about myself to start off with. I've been out of law school for quite some time. We won't go into the number of years, but I started out in Wichita as a prosecutor, went into private practice. Then I was appointed as a municipal court judge for the city of Wichita. I did that for over 4 years. Then I went to the Kansas Court of Appeals and worked as a research attorney and assistant director there for 9 years. Then it was in 2007 when I came to the Kansas Attorney General's Office. And like I said, I was assigned then to the BSRB back in 2011. So I've been there ever since. So I have been, so you have a lot of acts under the BSRB. So it's been a really learning experience to try and kind of understand where the nuances are for the different acts for the professions. So that's just a little bit of background for me anyway. We'll get started. Probably everyone there is a licensee. So you're probably familiar that, you know, all the steps and what you have to do to qualify to get licensed. And that's nothing new. Almost everyone who's licensed has a board that issues the license, and they are done through statutes and regulations that they have to comply with. The reason for the statutes is that to make sure that professionals who practice are competent and they do not pose a risk to the public. So you, like I said, you do that through statutes that have been enacted by the legislature. So that is how you get your powers, is through the legislature. They are not that you can do anything you want to. There are limitations on those powers. The board is created, or all professional licensing boards are created by what we refer to as enabling legislation. That establishes the board's forms, such as how many members are going to be on it, if they have certain qualifications they have to be, what the mission of the board is, what the powers, functions, and their tools and enforcement abilities are. For that reason, we call a board a creature of statute. Means very simply, you've been created by statutes, and so your power is dependent upon those statutes, and any exercise of authority under the statutes have to be what is contained within those statutes. You don't have any common law authority. So that's why it's important that you be very familiar with what the statutes are. A lot of new board members, especially, they say, well, there's no statute that prohibits us from doing this, so we're going to do it. And that's not the right question. The correct question is, what statute authorizes us to do this? So that's what is the main overriding goal of it. If the statute is silent on your authority to do something, then you're probably not going to have the authority to do that. You also have other limitations, which is the constitutional limitations, such as due process, equal protection, so that way you cannot act in a manner which would result in some sort of disparate or inconsistent treatment if the people are treated similarly, or you can't have different standards for different types of people. You cannot act arbitrarily or capriciously or vindictively. And that's the simplest way to think of that, is that you can't, if you have licensees who are similarly situated, say that they have about the same education, the same experience, they've made a violation, it's very similar in severity, you cannot punish one more harsh than you do the other. It just because perhaps one licensee kind of got under your skin, that's not going to be a basis to it. Other constitutional rights may be free speech, so you can't stop a licensee's free speech. The rights of privacy, you do not have rights for unseasonable search and seizure. And also on vagueness, you can't establish regulations that are vague. Regulations need to be written so that they're clear and understandable. People know then what they can and cannot do. So as a creature of statute, the legislature keeps control over the board. So if there is something they decide they don't like, they can repeal a statute or amend a statute to take care of that. They can even repeal the entire act that sets up the board so that there is no board anymore. So oftentimes as new types of professions are added, they will add a board member to it through a statute. So if they will go ahead and amend the statute to add board members, they can do that. That happens from time to time. A lot of times it's a struggle to figure out where the boundaries lie and what they can and can't do. One of the things that you see struggling with is, board members struggle with, is whether something is mandatory or discretionary. And it's the easiest thing to think of is that when the statute uses the word may, that's discretionary. So that you cannot create a bright line rule that says if this, then that, or everyone will, this is a straight across the board rule. Discretion means that you have to look at everything on a case-by-case basis and weigh it and decide then what is the best act to take based upon those particular facts. Shall is different. Shall is mandatory. That means that you have to do that. And a good way to think of how these two can interrelate is when you're issuing a license. The licensure statutes typically read, it says that you shall give someone a license if they meet the following qualifications. So they have to be like 21 years of age, have a certain degree that includes a program with so many hours of it. So if they meet all of those qualifications, then you're in the shall and you have to give it to them. However, there's another statute that comes into play and it's discretionary. It says may. It says the board may refuse to issue a license to someone who has done any of these particular grounds for for that. Those would often be that they have lied on their application, they have procured it in some fraudulent way, they have a felony conviction, and they have not shown they've been rehabilitated. Those are the may. So although they may be qualified for licensure, there's other reasons then that perhaps that the board can deny the license if they don't think that they should be licensed, that they will in their quest or their upholding their duty to protect the public. So that's kind of how those two can work together. So it's oftentimes you have to remember to look for the shall and the may so that you know when you have discretion and when you do not have that discretion. The other thing that the overarching thing that applies to everything that you do, the whole purpose of the board is to promote and protect the public, not the licensees. And sometimes that's hard for new board members and committee members. They want to do what is, as a licensee, they go, we've got these problems as a licensee. We want to change this things so it'll make it easier for the licensees. That's not what the board does. They have to look at it. Does this change still protect the public? So that's what they're looking at. And that can be so hard because when you come into the board, you will often have multiple hats that you wear. You're going to wear the hat as a board member, in your case, as a committee member, as a licensee. Perhaps you also are an employer. You are also on a school, perhaps you work for maybe an educational institution, you teach courses, so that when you sit here on behalf of the board, you need to remember which hat you're wearing and put on your hat that is the board member hat, take off your hat as a licensee or as working for a school or working for an employer, because the question is not as an employer, would I hire this person? That's not the question. The question is, if we license this person, will the public be protected? And the two analysis for that can be quite different. So it can be a learning experience. The functions and duties, the board can function in 3 different ways. If you go back to your government classes, there's 3 branches of government: executive, legislative, and judicial. And that's kind of the same thing that the board has, and they do it all as in one group rather than 3 separate branches. The executive is the administrative function, and that's how they carry out their duties, such as licensing and disciplining licensees. In doing that, they have certain obligations that they have to follow. It's also to review their statutes and make sure if there's any statutes or regulations that need to be amended or enacted, that they take the steps to do that. So they have other acts, though, when they do their functions that they have to follow with, such as their open meetings. When you're having meetings, you have to follow the Open Meetings Act. Any records you create or keep or possess are subject to Open Records Act. And those 2 acts are to ensure that your business is conducted openly so that the public knows what is happening. Judicial authority, that is basically your licensing, you're acting in a quasi-judicial capacity, which means that you have the authority to make findings of facts and conclusions of law and issue a decision. Those type of functions are going to be under the Kansas Administrative Procedures Act, and the Kansas Administrative Procedures Act is basically a due process act. You have constitutional due process and statutory due process. This is a statutory due process. That way there's uniformity across the board in how people are treated and how decisions are made, so that we don't have, and if you follow the CAPA, then you're probably not going to really have any violations on the procedures you used to make your decisions. Your legislative authority for a board is typically going to be, you don't enact the statutes, but perhaps you're going to make amendments or make recommendations to ask the legislature to adopt a statute. You also are going to enact regulations. Regulations have to be done according to the Rules and Regulations Filing Act to make sure that they are legally enforceable. But once that's done, then they do have the force and effect of law. And we'll talk a little bit further about that particular process. But The statutory process is, again, to protect the public. So a regulatory board implements and enforces the statutes and the regulations. And at times you have internal policies that tells your staff how to handle these matters. So that, again, that they're all uniformly done. You have to understand the difference between the statutes or regulations and a policy to make sure that you don't get them mixed up, because a policy is not the law. So you cannot be making someone comply with a policy. As we said, statutes are by the legislative authority, and that's through the Kansas Constitution, and then they are signed by the governor. Once they're published, then they're going to become law. Most statutes will come effective on July 1. However, the legislature can give it a different date. Sometimes if they feel it's important that it become law quicker, they will say upon publication in the register. So every now and then you will see a date perhaps in March, anywhere from between March and June. A lot of times they want to delay it. Typically that is so that the agency has time to gear up to put the new law into effect. So they may delay it until January of the next year. If you see a need, and as we said, the board can, when they fail to carry out their duties, they need more statutory authority, then you have to go seek that legislation to be able to expand your scope of authority. Regulations are not adopted by the legislature. They are adopted by the board. You have to have statutes, though, to adopt those regulations. There's two types of statutes. One is an implementing and one is an authorizing statute. The authorizing statute is pretty much what it says. That it will read something to the effect of that the board is hereby authorized to enact regulations to administer, implement, and enforce the provisions in this act. The implementing is going to be, that is what you are working on carrying out. So basically the subject matter that's in the statute and the subject matter that's in your regulation should be related. Once they have been drafted by the board and they've looked them over and they say, yeah, that's good to go, they're next going to go over to the Department of Administration, and there's a person over there who reviews them to make sure that the style, organization, and grammar are consistent with the policy that they have for regulations. And that sounds like an easy task, but drafting regulations is it can be a Herculean effort to get them all correct, to get it to look and read the way that they're supposed to. Then after they have been, they will also, I guess I should back up a little bit. Once they've done, they have 3 steps. They have to have 3 stamps on them to go into effect. Right now, it's the budget office stamps them first to show that there's no economic impact that's going to be hard on businesses, the agency or so forth to do these. Then they go over to the administration for approval for style, organization, and grammar. The next step is to come to the Attorney General's office, where they are then reviewed for legality. So we're looking again, are the statutes that are authorizing and implementing that have been listed for that particular statute correct? And do they also not violate any constitutional principles? Once that happens, as I said, then they're going to have a stamp from each office. They will then be taken to the State Secretary of State's office, who will then do 2 things. One, they will be published along with a notice of hearing, and then they will also be set up to go over to the Joint Committee for review. So you have to have that hearing within 60 days of publication. So when you have go over to your committee, then it's typically the executive director goes over and explains to the committee why they are adopting the regulation, what it's changing, what it's doing, what the purpose of it will be. They will have questions typically, and those are answered. It's often followed up with a letter to the agency, and you need to answer the letter so that they are happy with what you have done. If they don't like the regulation, of course, they can go in then and adopt legislation that changes everything so that you can't do what you're trying to do in a regulation. So that's kind of really why you need to answer their questions to make sure that they're okay with it. Once you go to the hearing, that is a public hearing. So anyone who wants to come and be heard on that can come and attend it, or they can submit written testimony. And that has to stay with the regulation. Once the hearing has done, the regulation will go back to the board. The board will then, staff will then tell, the board doesn't have to be at the hearing on the regulation, the public hearing. So staff typically tells the board, this is the testimony that we heard. This is the response we got back from the joint committee. That, and then they have to decide if there were any kind of comments, whether or not that regulation needs to be changed. If so, they make the changes, and then it goes through the process again if those are substantial changes. If they are not, then typically you get the stamps on them, but you don't have to go through all the hearing process if they're just minor changes. That is for a permanent regulation. It's pretty much the same for a temporary regulations on getting all the stamps through. It's a little different. You don't go to the joint committee, you go to the Rules and Regulation Board. The difference is if they do have the authority to deny it, the joint committee does not. But the Rules and Regulation can deny a temporary one if they don't think you have met the standards. If they do agree to it, then it gets published and it's effective immediately. However, that it only lasts for 180 days. That's basically to set something, a law that you need to protect the public will then be in effect while you work on getting your permanent regulations finalized. If you can get it, you can ask to have it extended once for another 180 days. That doesn't happen too often. It's a bigger hurdle. Because they're going to want to know why you didn't get that accomplished. So if you have a temporary and a permanent, you're going to run them side by side so that consequently you can get that permanent into a place right away. We've kind of gone over the procedure. When we're talking about the statutory authority, sometimes this is kind of a goofy analogy, but it's maybe helps people, I think, understand what we're talking about a little bit. When you look at the statutes to adopt it, if you think of it, and I didn't come up with this, I stole it from my predecessor, is that the legislature has enacted statutes that in essence make a corral, and it's got little borders around it, and they've said, okay, you can have thoroughbreds in your corral, but that's all you can have is thoroughbreds. And then they say you can adopt regulations to determine what the qualifications are to get into that corral and what they have to do to stay in the corral and how they're going to get kicked out of the corral. And so you do that. So you put up, you've got to have so much training as a thoroughbred, win so many races or whatever, and then you can get into our corral. And then you have to compete in so many races, or you have to do so much more training to stay in the corral. Or if you start to lose races, then we kick you out of the corral. That's kind of that how you make those decisions. But once you decide, you go to the circus, you see a zebra, or you go to the zoo and you see a zebra and you go, that looks really cool. It's very similar to my thoroughbred. I would love to have this zebra inside my corral. You can't do it because you don't have the statutory authority to have zebras in your corral. And that's really kind of the way to think about it, is what boundaries do you have, and are we within those boundaries? So when you're making a regulation, you need to decide before you probably even begin is to think about why do we need this? What's the purpose of it? How are we going to implement it? Does it really need to have the force and effect of law? A regulation cannot repeat the statute. So if you repeat the statute, we're going to delete it unless somehow it's needed for the context of it. Is it self-directory? And that just means, or self-regulating. That's another term we use, because basically you're telling yourself to do something. The board shall do this. You don't regulate yourself. You're to regulate the licensees and the applicants. And is it informational more than regulatory? If it's just something you think people should know, then that is not regulatory. Regulatory is law. It's to tell people what they can't have to do or what they cannot do. So that's sort of what you need to keep in mind when you're thinking about maybe assisting the board on doing some type of regulations, because oftentimes the advisory committees will look at whether or not a regulation needs to be amended and so forth, and make recommendations for adjustments. As a board, you've got number of acts that you have to be very familiar with. And the first thing I say is to read every act. When you become a board member, don't read the act that pertains to your license. Read all of them, because you're going to have to deal with all of them. So you also need to read the board's enabling acts. Those are the ones that set up the board, so that you know what its powers and authorities are at. You also need to keep rereading them as issues arrive, so that you're familiar with them and you understand them. There's regulations for each act. There's not one set of regulations for all the acts. Each one has their own set of regulations, so you've got to be familiar with all of them. Sometimes they're very familiar, sometimes there's differences, and the board does struggle sometimes with where there's those differences in the regulations, such as like supervisory hours, the direct client contact and all that. So there are little nuances that, that's why you need to kind of be familiar, have that regulation or statute in front of you, so that you understand for this particular issue or this particular case, what it is that you need to know. When you see that you have statutes or regulations that really are vague, you don't understand what they're saying, then probably the public doesn't understand it, or the licensees. And that's when you need to stop and say, can we make this better? The rationale, and we hear it from time to time, is like, well, we've always done it this way. That's not going to be a defense if you get sued. So that's why you always kind of want to be on the lookout. Is something changed that we need to be working on making some amendments? Again, I can't stress it enough. Make sure you're within the authority granted. If you're not sure, then always, reach out to me, or have David or Leslie reach out to me. I mean, Leslie, when she makes a phone call, can we do this? I go, well, what's your statute? Point me to what statute you think gives you the authority to do it. That's going to be my response back, is why do you think you can do it? I need to know what the statute says so I can read it and interpret it. If we can't find a statute or regulation, then the answer is going to be no. Oftentimes your statutes become outdated. I think a few years ago, they went through their licensing acts. They got most of their outdated statutes repealed. There might be a few more that could be done. The easiest explanation is that years ago, before you had CAPA, every licensing agency had statutes that talked about a hearing process. Those became obsolete once you had your statutes in 2016 that said everything is under CAPA. From the moment you get an application or a complaint until you get it done, it's under CAPA. So they had to go in and repeal some of those old statutes because they were just no longer applicable. The overarching thing as a board, when you're dealing with licensees, is that what you want to do is to basically, the whole purpose is to get them into compliance, as long as that will protect the public. So you don't want to be vindictive and go, well, they really need to learn their lesson here. That what you can do if you have a licensee who has been disciplined multiple times over the years and they're just not getting it, whether it's negligence, they don't want to bother reading the laws, or they just don't care what the law is, then yeah, in those type of instances, that's when you're ready to take the harshest, the harshest penalty that you can find, or those who just don't get it and don't want to change their ways. But for like something simple, they took all their CLEs and maybe they were short 2 hours and they thought they had it. They just miscalculated when they submitted their application. That may just be a warning letter, and the warning letter goes into the file. You didn't, but as soon as they realized that, they took the additional hours, they got it into you. So it's sort of like, okay, you goofed up, here's your warning letter. It's going into your file. So, make sure that you don't do this again, because the next time you may not get a warning letter. So But the main thing is that when you do have issues, that you're not there to protect the licensee. You're not to feel sorry for the licensee. You're to handle it so that that licensee, so that the public is protected for that licensee, that the licensee is not going to harm anyone. Conflict of interest is basically you have some other type of interest that is not congruent with what the board does. It could be any kind of interest, financial, direct, indirect, a business transaction. It can even be a professional activity. And this is oftentimes what happens when you have a board of licensees, because usually people who are on boards are very active people. So they may not only be, they may be on other boards. They may be on the board of their professional association, whether it's the state one or the national one. And that can be a problematic thing because they go to their association meetings and they hear some really great ideas and they want to come back and they want to implement them to the board. And you got to be very careful about that. Are you there pushing this on behalf of the association, or are you doing this as a board member? And are you being keeping the board fully apprised? Where did you get this idea? Why are you doing it? Did they ask you to come and present their point of view? You do not present their point of view. That is not what your role is. If they want to have someone come and present a point of view, then they come to it and they bring their own staff, not the board member. The board member doesn't say, hey, they come and they've asked me to do this. You have to tell them that, no, I am a board member. I can't represent you. You will have to have someone from your own organization come, and you are more than welcome to come speak to the board at one of its meetings. Just let us know and we'll put you on the agenda. But you don't speak on behalf of a different association. If you have a conflict of interest, you need to disclose it. And if you feel that that you cannot set aside that interest, or it won't even look right, it's called like the appearance of impropriety. It's a pretty common tool. Then you probably need to recuse yourself, but you just need to be careful that you don't overuse the recusal just because it's going to be uncomfortable for you to exercise your responsibilities as a board member. So that's probably, sometimes it could be a business interests, such as that you are an employer, you've got a business going on, and this other licensee has a business just like yours down the road. And if they went away, then you'd have more business. So that kind of also covers a little bit of the potential conflict, personal gain bias. You know the person, you don't like them, and you just can't get rid of it. Again, another personal one may be that your supervisor has someone who's coming up for licensing, and she wants you to vote in favor of the person, of her friend. So confidentiality as board members, and even perhaps as advisories, you may come into some very confidential information. That confidentiality continues after you leave the service of the board or the advisory committee. So you are not able to share that information with anyone else outside of that group. So confidentiality can come in a couple of ways. One is the executive session. There are two types of executive sessions that are most applicable to the boards. One is personnel, and the other one is legal advice. Personnel, you may find out, is to discuss the staff of the board. That's probably for the advisory committee members, not going to come up because you don't have any control over the staff, but the board does. And there you're talking about very private information for employees, and you don't want that to become a public. And in addition, if anything is said and they would think that you've defamed them, that type of thing, you don't want to end up in a big lawsuit mess. So that's why you have like a personnel exemption. The other one is the legal advice. Again, you go into executive session to protect the attorney-client relationship. So the legal advice that the attorney gives you remains confidential, and it's not available for the public to see. So what does that mean? If you go into an attorney-client executive session, when you come out, then you don't start saying, well, when we were in executive session, we were saying blah, blah, blah. that's now you've just blown the whole reason for going into executive session. If you're going to discuss it, you've not only blown the confidentiality, but you've blown the reason for having the executive session, and you're likely to find that you're going to have someone file a open meetings complaint. That does happen. Why did they go into executive session if they're just going to come out and discuss it? So that is why it's important. In addition to waive attorney-client privilege, it's not for that one board member. It has to, that issue has to come before the full board, and there has to be a vote on it, on whether or not they want to waive that confidentiality. Another way it can come up is in deliberations after a hearing, or any kind of deliberations, such as on a to do like a summary proceeding order or consent agreement, that type of thing before it would go to hearing, because that's the quasi judicial deliberations, and it's that you're acting like a judge, and so or a jury, and so like if you think of it as being a jury. Well, after the hearing has ended, the jury goes back and they deliberate. The parties don't get to know what's going on. The public doesn't get to know what's going on. The judge doesn't get to know what's on. That's the same thing for the board deliberations. Those are secret, and they're not, you don't reveal them. You cannot go in and make board members say, what did you deliberate about? Those are protected. So there's if you are, like I said, you don't do your hearings anymore under the Open Meetings Act, but in days when they were under the Open Meetings Act, there is a specific provision that says quasi-judicial deliberations are not a part of the open meeting. So that's how those are protected there. And under CAPA, it just says that the public can attend the hearing. So that's how you're protected. Ex parte communications. This is more likely going to come across when you have an application or a discipline matter pending before you. And it means because you're acting as a quasi-judicial role, you cannot be talking with other people who are not involved in the case. So if someone would say, your next door neighbor says, hey, I know that you're got a case up with this certain guy. I have some information for you that you really need to know. You can't talk about that because neither the licensee nor is the assistant attorney general that does the litigation for you there, so that they know what you're talking about and so that they have the opportunity to be heard as well. So in essence, it's like having a secret conversation that you could make your decision on that they would not be privy to. If somehow you do get caught up in ex parte communication that you don't realize it, then you need to, let's say that someone talks to you and you don't know that there's a matter pending, but then the matter comes up, you realize, oh, I know about this case. I've heard about it. I've had discussions with it. You may then have to, what you have to do under the CAPA is you have to put that on the record that you had an ex parte hearing, when and where it happened and what was disclosed. And that way, if a party feels that you may be biased, they can file a motion to have you recused yourself. So that's why it's very important. And you may just want to recuse yourself up front. You can do that too as a part of the ex parte. If you think this is, I can't, be unbiased now and be fair and impartial, I need to do that. And we talk a little bit already about professional activities. Again, one other thing, going to professional conferences and social events, we do complaints about that too, because you may have multiple board members at one of those things and people will see them talking. And so they're thinking they're doing board business. And so that's the problem. Even if you don't have a majority there or you're not talking about board business, you may get caught up in a coma complaint. So if you are at some place that is like a professional conference or social event, be very mindful never to discuss what is the business or affairs of the board, because that could trigger a meeting if there's enough of you around. So that has happened to local governments and to some boards. So don't discuss anything that's board business. The other type of conduct that as a board member or a committee member you need to know is that not speak on behalf of the board unless the board authorizes you to do so. So if you do want, you still have your First Amendment rights, but if you do go somewhere to speak, make sure that they understand that you are speaking on your behalf as a personal, citizen, and you are not there on behalf of the board. This may come up right now at this time of the year. You're going to see it with the legislative session, is that, a board member will want to go over and talk about pending legislation, and it may not even have anything to do with the board. It's not a board bill, or it's kind of may touch upon the board, but it's not really related to the board. So you just have to know, I'm so-and-so, I'm here myself. Although I'm a board member, I'm not speaking on behalf of the board. They've not asked me to give any position on it. So that's clear that it's their own opinion. Okay, you've heard me mention already a little bit about the Kansas Open Meeting Acts. That is to require that any government entity, that when they discuss the business, it's out in the open so that the public can see it and they can know what's going on. The provisions to have it open are interpreted very liberal, and the exceptions to close it are very narrowly construed. So it applies to just about all legislative and administrative bodies and agencies of the state, and even a lot of the subdivisions, such as like your city councils or your county commissions, that type of thing, are also under it. So you're not alone. The term they use is subordinate groups. It's not defined, but basically, if the group is becoming an extension of the entity that's under COMA, then they're going to be a subordinate group, especially if they receive money or funding or support from that group. So that's how the advisory committee gets hooked in to COMA, is because the board's subject to COMA, and then you are a subordinate group of the board. So you are now also under COMA. And we've talked a little bit about the quasi-judicial proceedings, and when you're under CAPA, there is an AG. We finally determined that when you are under CAPA, you are not under COMA, but to be under CAPA, you have to have a specific provision that says you're under CAPA, so that they can be mutually exclusive. COMA won't apply to private individuals. It also doesn't apply to the judiciaries. If the board has staff meetings, those are not open to the public as well. So what is a meeting? It's any gathering or assembly, and you can be in person, or you can use any other kind of electronic means, such as your telephone, your video conferences, so Zoom and Teams and all of those come under that. And it has to be a majority of the membership of the agency or the body that's under the COMA, and that the purpose of the meeting is to discuss the business affairs of the public body or the agency. A lot of times you'll hear people talking about a quorum. That is old language. It used to be in the COMA. It used to read that it was a quorum of a majority. So if you had, that meant very few people could be present for a meeting. So if you had like 12 members, a majority would be 7. So a quorum of that majority would get you down to 4. So 4 people out of 12 would constitute a meeting. So you had to be extremely careful. But now they've taken out that quorum, so it's just a majority. So you have 12 members on your board, then your majority is going to be 7. And it doesn't also matter what you call it. You don't have to call it a meeting. A lot of times agencies will have what they call work sessions or retreats. Those are still open to the public. You still have to give notice to people who have requested notice of your meetings, and you still have to let the public come in and observe that meeting. A discussion is just that, a discussion. So you don't have to take any action. You don't have to take any votes on it. It's just the discussion. The presiding officer has a duty to notice that, but you can delegate it. So typically that goes out to staff that does the notice. That's those emails that you get that pop up and say, here's all the meetings that the BSRB is having, or here this meeting has been canceled. So that's the notice that you're giving, and it tells them how, when, and where the meeting is going to be and how they can attend. The individual does have to request notice of the meeting to get that. There's no formalities. It can be verbal or written. Most likely, you would like to have it in writing so that that way you know how you can contact them, and especially what meetings they want to come to. If it's all of your meetings, or if it's just the board meetings, or just a committee meeting. A request is only good for one fiscal year. So what will typically happen is that like early June or something, most agencies are going to send out a notice to all of the people who've requested notice and say, you know, your notice is going to expire effective June 30th of this year, unless you tell us you want to remain on the notice list. And if they don't notify you that they want to stay, then you can drop them off. Sometimes that's just kind of a way to keep your records clean. However, you can't drop them off unless you've given notice to the requester that they are going to be dropped off if they don't ask to be on it. Meeting procedures is something a lot of boards struggle with at the beginning when because especially if you belong to other associations, they have adopted probably some type of formal rules for how they do the procedures. There is no statute that requires the board to follow any type of statutes or any types of rules. So you're not required to follow Robert's Rule of Orders or anything else similar to that. Actually, we advise you not to follow anything like that because it can become very strict and formal. That people don't know what they're doing. They have questions, and we can't give them advice on it because it's not a legal issue. Also, the Robert's Rules of Order books is very expensive, and you'd have to have one on hand. So if questions arise, it can be looked at. The main thing is that you just want to have a way of proceeding because like on Robert's Rule, if someone votes a certain way, they may not be able to bring up to vote on it again or to bring it up for a vote again. And so your duty is to protect the public. As new information becomes available, you may want to go back and be able to address that subject matter again. So that's why it's really not so good to have that. You are not required to have a public comment in your meetings. Most boards do. They do allow it. Some put it at the beginning, some put it at the end. You can limit the amount of people can talk so that way, you know, you do have limitations on how long you're going to be there. And the main thing is that the people who are in attendance or who are speaking, that they do not become disruptive. You can have them removed if they become disruptive. The other big thing is you cannot vote by secret ballots. There is an AG opinion out there that probably it's very old from the 80s that addresses secret ballots, but I would advise you never to follow it. What it says is that a secret ballot would be like you write down on a little piece of paper what your vote is, and then you hand it in, and then the chair then would go open them all up and say, okay, count them up and say, we've got 4 yay and 3 nays. So that you know what it is. Well, you don't know how each member voted that way. This old AG opinion says, well, if the board member writes their name on that ballot, then that's okay, because if someone wants to see how they voted, they can go in and make a core request to look at the ballots to see. No, that's not what COMA says. COMA says there's no secret ballot. So that means at the meeting, they have to be able to see how you voted. You can't just have a secret meeting, a secret vote. So don't count on, follow that AG opinion, think we're good. Because I think if someone makes a complaint, you could say that, no, you could have a judge saying, no, that's not correct, and end up in trouble. You're not required to have minutes, except when you have an executive session. The motion to go into executive session does have to be kept in minutes, and it pretty much has to be verbatim as to what the motion stated. So that's why it's best to write it down and read it, so that way you've got a good record of what was actually said. You also don't have to have an agenda, but if you do have an agenda and someone wants it, then you have to make it available to them so that they have a copy of the agenda. You cannot take binding action in an executive session. You can take a consensus consensus is just to say, okay, we've discussed this enough. We think we know how we want to go on this, but you don't vote on it. You have to come out into the open meeting part and then take a vote if you want to take any type of action based upon what was said in the executive session. Executive sessions are governed by statute. As we know now that there has to be a motion made, seconded, and carried. There are certain things that must occur in the motion. Have to have a statement of the subject to be discussed, but you don't want to be careful enough that you don't reveal the confidential information. The justification, that's listed in the statute as to the reason why you're closing the meeting. And as we said before, that's typically going to be like for personnel or attorney-client privilege. Then you have to state the time and place it's going to resume. That motion has to be permanently retained in the board's records. And I've listed some of the common reasons that we see in our office for complaints under COMA. Prosecutions, you can be prosecuted for violations of the COMA. They are civil. Any person can bring a COMA violation, or a county or district attorney can bring a COMA violation, or the attorney general may do it and they can bring it in district court. If a complaint is filed in district court, it is supposed to get precedence over the other cases. If it's filed fast enough, the court can undo whatever action was taken. They can also do an injunction to stop you from taking action or to make you do what you were supposed to do, or they can just issue a declaratory judgment saying this, you shouldn't have done this. You didn't follow COMA. Okay, now if you've fallen asleep, wake up. The penalties for COMA violation can be $500 per board member for each violation. So if you committed more than one violation at a meeting, you could have a maximum of $500 for each one. And read very carefully when I said per board member, not the board. So this comes out of your own pocket. The board doesn't pay it, the state doesn't pay it, you pay it. That's why you need to be really careful about not having conversations outside of the meeting. And when I say conversations, it doesn't have to be a telephone, an in-person conversation, and it doesn't have to be a telephone conversation. It can be emails. Emails are another way people get caught up, is that you send emails, an email goes out, let's say David, to give some just a FYI, this is to let you know what's happening over at the legislature. Someone hits reply back and they say, oh, well, I think we need to tell the legislature this and that, or we shouldn't be in favor of that. And then everyone kind of jumps in on that. And now you've got a COMA violation if there's a majority starts discussing it. The best thing is if you get an email, do not use reply all, do not even reply, don't forward it, don't nothing. If you need to talk about it, you send a separate email to Dave saying, I think I would like to have a meeting set up by this to discuss this subject. Can you set it up? That's what you need to occur. If you want to discuss it, then get an open meeting going. Don't have your discussion by emails or phone calls. Another way it occurs is that it used to be called the telephone calling tree. And that would be one person would call up, usually like a staff member, and they call each board member. They ask them, how do you feel about this? And they would kind of write down. Then they go, oh, well, I've got 6 board members in favor, 2 not in favor. So the majority is this. And then they would act upon that. That's the calling tree. That was when you try to poll everyone and tell them, hey, I've talked to Joe. Joe said this. Do you agree with Joe? That type of thing. So you don't want that. So you have to be very careful just not to engage in any type of discussion. If you want to discuss it, then ask for that meeting. The Attorney General also has a new authority since about I guess it's going on 6 years now. We do have someone who prosecutes COMA violations, and they have the authority to enter into consent agreements. So if you go, oh my gosh, yeah, we messed up, we tripped over something and we didn't realize that we're not going to do it again. And you can admit to that. So it will contain admissions of fact. We can require you to then to go to a training that we have approved. There can be a penalty. This time it's not as bad or as egregious. It's only up to $250. Usually fines are going to be set for egregious things. They're not going to be set for minors. For minor things, typically, it's going to be that you admit you did what was wrong and go do training. They can require, though, that you sign it to actually acknowledge that you did violate the law. And they can also tell you to cease and desist from any further violations. So we have the authority to investigate and do subpoenas, that type of thing. So that's how come investigation can come up with a lot of information on what actually occurred. Open Records Act is the other act that is to have openness in the government. And really what that means is that any record that the board creates, possesses, maintains, keeps, that's, that you have it, then it's a board record and anyone can request a copy of that record. So what does that mean? And when I say it's not just paper records, it could also be videos. It could also be books. It could also be emails. So if you're emailing someone, you need to be very careful about what you say in your emails, because this has happened, is that you get kind of smart alecky and you say something in an email, someone makes a core request and there's no basis whatsoever to read that and to not disclose that email or not to redact it. The full thing's going to be disclosed. Then you may find your email on the front page of the Topeka Capital Journal or the Kansas City Star or the Wichita Eagle or any other place, and it gets to be a little bit embarrassing. So always keep your emails professional and make sure that you are not going to say anything that could be very embarrassing to you or to the board. So under CORA, they have a Freedom of Information Officer, which I believe is Leslie. That person is responsible for handling then the CORA requests when they come in. There also has to be a policy that's available to the public on how you handle your CORA request. And on your policy, you have to say who is your records custodian, the fees you're going to charge, your office hours that's available for someone to come in if they want to look at it rather than have a copy. You can charge the fees for doing this. So it's the charge to go find the records, to do a search, to get them, to copy them. And then if you have to redact them, there are statutory reasons where you can keep information that's in records closed. And so the time and expense of redacting those things so that they can't read those are done. Typically for these, such as if it's a discipline, the medical records are not disclosed. The name of the victim or the client will be redacted, so that's not disclosed. Personal identifying information, such as date of birth, social security numbers, all of those types of things. Your home, if we have a business address and a home address, we're going to redact your personal address and phone number, things like that. So they have to be acted upon as quick as possible, which means that there has to be a letter written within 3 days that says, yeah, we got your receipt. We're in the process of looking for it and we'll let you know what we find out. Or if it's very simple, you can find it immediately, copy it, and there's no expense in essence. There may be expense, but it's de minimis. You can just go ahead and give it to them and say, here's what you requested. Thank you. And again, CORA is just like COMA. There's a presumption of openness, and anything that says that something is closed is basically read that it is strictly construed. And the burden this time will rest on the board to show that they are exempt. And I give some of the reasons there that the statute allows you to close some things out. As I said, you can get fees, but they are for actual fees. And so you can make them pay the fees before you provide the records. CORA is a civil act, not a criminal act. And again, any person, a county or district attorney or the attorney general can bring the civil prosecution. So what happens usually if you have redacted something or said this isn't available for disclosure, then the district court can do what's called an in-camera review to see if they agree with you or not. That such as that you didn't, federal law prohibits, like say, treatment records for addiction. Those could be not given. So to say, yeah, those fall within that federal statute, or that you have FERPA for education records. So transcript, they go, yeah, that falls within FERPA. So shouldn't, they had the right to not disclose that. So this is different, that if there is a violation, it's going to be the board that pays it. It's not going to be, because you don't handle the individual records for the board. It's not your responsibility. So it is the board that for those types of things that will have to pay any kind of a fee. They can also set forth an agreement that you're going to be complying it, and that you're going to maybe have board members or staff, whoever it was, to go through approved training and agree that you're going to not do it again. Okay, Kansas Administrative Procedure Act. Again, that is your statutory due process to make sure that everyone is handled pretty much the same when you're processing this. It applies to your applications. It applies to complaints. And this has been pretty, I think, beneficial to the board. As I said, up until about 4 or 5 years ago, they did not, each act had different CAPA provisions, and they were all over the place. And it was very easy to make a misstep, and it should have been under COMA rather than CAPA. And so we went in, and every act now pretty much has the same language in it that says administrative proceedings and disciplinary actions regarding licensure. And then under this act shall be conducted in accordance with the Kansas Administrative Procedure Act. So before that, it was just like, well, maybe CAPA applied for revocation hearings. So anything else, like an application, it wouldn't have applied. You'd been under COMA. So that's why, and the thing is maybe you start your discipline out, you didn't know what you were going to do. You didn't know yet if it's going to be revocation. And so consequently, it was kind of a mess. The only act that you have that reads a little bit different is the Behavior Analyst Licensure Act. And it says any action taken under this section which affects any license or imposes any administrative penalty shall be taken only after notice and opportunity for a hearing. So not everything may be covered under CAPA because of that language. Luckily, I think you've only got maybe about 100 people who are licensed under that act. And as far as I know, that's not been a big issue. But for behavior analysts, if we get a complaint against them, or an application where it looks like we may have, they may not qualify, we're going to have to take a closer look at that. But when the big advantage to CAPA is that the only thing that the public has the authority to appear at is the hearing itself. That has to be open to them. So consequently, when you're getting an application or a complaint, your probable cause for a complaint, all of that is done under CAPA. You can have it closed so that only the board members and staff are looking at that information and discussing it. So that's the big advantage. You don't have to think about, having to go in and out of COMA to do quasi-judicial deliberations and stuff. You also don't have to take a vote, a formal vote, like you do under COMA. It's basically you need to discuss it and make sure then what the majority opinion is or majority of the boards for its decision. Your decision is not made through the vote, it's made through an order. The order has to be follow certain guidelines for findings of facts, the applicable law, applying the law applying the facts to the law, and then make a conclusion as to what, if there were violations, and if so, what the penalty will be. So you always have to be real careful about what's under COMA and what's under CAPA, like board minutes, board agendas, those are going to be under COMA. You don't have those under CAPA. Discussions to amend regulations or statutes or guidance documents or policy documents, those are going to be under open meetings. delegating authority to someone, that's an open meeting. So your budget, that's under open meetings. Contracts, open meetings. Policy decisions, open meetings. So the main thing I think to think about whether you're under open meetings or under CAPA is there an identifiable person, either an applicant or a licensee? If that's yes, you're probably going to be under CAPA. So I think we've covered a few more pages there. When you are under CAPA, there is discovery. So that means both parties can look at the other side's position. So say if it's an applicant, they have the right to request copies of the board's application packet of all the material they have. If it's a discipline, they can make a discovery request then to get what has happened in the investigation. Sometimes how long it's going to take to get all the discovery completed can vary. It might take 3 to 6 months. It really depends upon the complexity of the case. You do have the authority to, for the board can either do hearings or they can send it over to the Office of Administrative Hearings. The board has done theirs so that applications, they do that. Discipline cases are taken over to the administrative hearings. And you kind of have to, that becomes important because once a decision is entered, administrative hearing office can only do an initial order. What that means then is it's to have it, is that once that order is issued, then someone has the right to have the agency itself review that order to determine if it's correct. The person that reviews it's the agency head, which could be everyone other than the board members who were initially involved in the investigations and decisions, and that would be the complaint review committee. So it has to be those independent people who are reviewing it. If the board does it, there is no further review. They make their decision. They can make a summary proceeding order, which then gives the right to have a hearing. They do the hearing on their applications, and then they issue the final order. Once the final order is issued, then they do have the right to request reconsideration. If they still feel that they're aggrieved, they can continue on to the district court and appeal the decision. So the presiding officer's conduct, all board members who are hearing a matter are presiding officers. So the CRC, that is all the members there are presiding officers. For an application, every board member who hears it is a presiding officer. And those are the ones who listen to everything and make the decision. If someone does not show up for any proceeding or the hearing, they are in default, and you have 2 ways to go. You can make a default order, which says that you didn't show up. So what was said in the petition or the summary proceeding order is deemed true and correct, and you are hereby suspended or revoked or whatever is necessary, or the application denied. Or they can go ahead and have if it's set for a hearing and they were notified of the hearing and they don't show up, you can go ahead and have the hearing and go ahead and issue that order. That's final. A default order, the main thing that's the downside of the default order is they do have the right to file a motion to set it aside if they get it filed within 20 days. Then you have to decide whether they have shown good cause to set it aside, and then you proceed on. But if it's a final order, then they have to take it on up to the district court if they're not happy with it. And that's filing a petition for review. The district, if they do file an appeal, the district court is not authorized to do a whole new hearing and a whole new decision. What they're doing is a review, just that. And the reasons that this board decision can be challenged or limited to those 8 reasons that I've laid out there. Usually it's going to be an interpretation of a statute. That may be one. If you followed your CAPA, the procedure should have been okay. The other thing would be that whoever made the decision was not constituted properly to make that decision, or they were subject to disqualification. But the biggest one is going to be number 7, which is the Agency Act is not based on a determination of fact that's supported by the evidence, and that has to be substantial based on the whole record. So when they look at that, they're not looking at the record that supports what you did. They have to look at the whole record and then determine based upon the whole record was what you relied upon substantial or not. And so that's why you don't want to, if you have everything in the record based on one issue, or one set of facts, and then there's just a little tiny fact that is not going to be substantial. You have to be very careful of that. And that's why you do have assistant attorney generals that are there to help you and assist you to make sure that you get all the facts. They can be, your findings of facts could be quite lengthy because of this review, you want to make sure that it's clear that when you hear this, that you considered everything that was presented by both sides, that you weren't just one-sided, that you listened to both sides, you considered them, you weighed it, and came up with your decision. Number 8 is sort of like the Hail Mary. That's almost in every one as an alternative, is that it was arbitrary, unreasonable, capricious. And basically that just means that there's no basis in fact or law for what you did. Very rarely does that get granted. It might be that where this could come into play would be is if you had discretion and instead you used mandatory language. So, and that was not the proper way. So Kansas Tort Claims Act is what we're finishing with. As a Kansas Tort Claim Act, it says applies to employees. That's for when they get sued. The definition of employees also includes board members and the subordinate groups. So that's why the board members are covered under the Kansas Tort Claims Act, as well as the committee members. And so what that means is, why is that important? Because if you do get sued and it is within your capacity of what you are doing for the board, then you will get representation from the Attorney General's office at no cost. And we will also look to see if we've got a defense that will make this thing go away. So to do that, it has to be, what you have been doing has to be within your scope of what you were supposed to be doing. So what that means, that turns us back to where we started. Is there a statute that authorized you to do what you did? And if the answers to that is yes, then we're in good grounds. And if it was may, then you had discretion. So the question is, did you use that discretion? Did you look at the facts? Did you look at the law? Did you apply the facts to the law? And was that a discretionary decision based upon the facts and the law? If so, you've got a defense. On the other hand, if this was a shall and you had no discretion, they had this particular fact that disqualified them, then that's a shall, and you had no other decision to make. So that's your defense. So that's why it's important to always know what your scope is when you're doing something on behalf of the board. If you do get sued, remember to request for representation, and to do that, you have to submit a written request asking for representation and include a copy of the petition and the summons that you were served with, and you have to cooperate in your defense. We can choose not to defend you if you acted with actual fraud or malice, or you didn't make a timely request for representation. So if the time to answer has gone by, and now you come and say, please represent us, we can say no, because you waited too late. Or if what you did, actual malice, you knew that you had discretion, but you said, I don't care. I don't want to do that. I don't like this guy. I don't want him to ever license to practice, so that it was malice, then we could say no. One other reason that sometimes you see, it doesn't happen very often, but it does kind of raise its head from time to time, is if you ask for our advice, we give you the legal advice and we say, don't do this. You're going to get in trouble. You don't have the authority. This is, you need to listen to us and say, this is not proper. This is not legal. And you go, I don't care. You go ahead and you do it anyway. We say, this is going to be a violation, and you do it. We can say, no, you didn't follow our advice. Our advice was sound. It was correct. We're not going to defend you. And it's not that we're blackmailing you. It's that you can't have it both ways. You can't ask for legal advice, refuse to follow it, and then ask for our office to defend you. So it's a waste of our time to give you legal advice and then to defend you when you don't do it. And luckily that is rare. And so that's why I always say, if we give you advice and you don't understand it, ask us to explain it further and to go through the process so that you're comfortable with it. Then the other side to that is if we do give you advice, and then after we get the petition and so forth, they do the research and they decide, you know what, this was a really gray area, or the law changed and that advice maybe shouldn't have been given, or it should have been different because of this intervening law or whatever happened. And so they go, yeah, we're going to go ahead and defend you, even though it was something different that you were told to do. And what that does is it doesn't mean that you didn't commit a violation, but then you can go in and you can say, I did not act with fraud. I did not act with malice. I relied upon the advice that I got from my attorney. And then that will mitigate the damages, hopefully. So that's why, if you've got legal questions, come to us and ask us, because, then that it can be that, it gives you the defense if a judge would rule the other way. So that's the other thing. So the third thing to remember third thing on this is that if you are sued, do not sign anything, do not say anything, because we want to make sure that you are never misconstrued, that you don't make any admissions, so that, once we, represent you, we will be talking on your behalf, and you are not to be saying anything, whether in public or private. The mantra is that on the advice of my legal counsel, I am not going to comment. Let your attorney do that. So that is kind of it in a nutshell. I guess I did take almost 90 minutes. Any questions on what we covered? No? Yes?
I don't see any.
Okay, thank you.
All right, well, thank you for that. And then I think we're prepared to entertain a motion for executive session if someone would like to do that for us.
Sorry, Deb, I think you were cutting out a little bit. Did you say
Sorry,
you were looking?
I think we're ready to entertain a motion for an executive session if someone would like to do that.
Can I ask just a quick question about that, Deb?
Yeah.
Okay, so I saw the information for the connection for the conference call. So it will just be a conference call, no video, is that correct?
Correct.
Okay, perfect.
This is Lisa Carter. I'll make a motion to begin executive session.
Do you have the script?
I'm trying to pull it up. It's opening right now, if she doesn't have it.
Yeah, I'm trying to pull it up too.
Well,
Okay.
first, before we start to read it, how many minutes? I think probably, because we have to have that in there. So 30 minutes is, I think, probably pretty typical.
Okay. So that'll have to just be the fill in the blank when you get to that. It'll be 30 minutes.
Yeah, Deb, if you want, I can go ahead and read the language, and then somebody can move to adopt the language, if that would be helpful.
Very helpful. Thank you.
Sure. Okay, so the executive session motion would read as follows. Actually, do we just settle on the time for the executive session? 30
minutes.
30 minutes, okay. Okay, so pursuant to KSA 75-4319, the maker of this motion would move that the Addiction Counselor Advisory Committee recess into executive session for 30 minutes and reconvene the open meeting at 11:56 a.m. The meeting would be reconvened remotely by conference call at 1-877-278-8686, PIN 327072, and a link to the board's YouTube channel as stated in the notice of meeting that was sent to individuals who requested notice and published on the board's website, ksbsrb.kansas.gov. Justification is consultation that would be deemed privileged in the attorney-client relationship with the board's legal counsel, Assistant Attorney Generals Janet Arndt and Lainey Bernard. The subjects to be discussed in the executive session concern Kansas Open Meeting Act during the disaster emergency declaration. Board staff who are included as the client in the executive session are David Fye and Leslie Allen.
All right. Someone want to make that motion as read by David Fye?
This is Dulcinea Rakestraw, and I make the motion as read by David Fye.
Do I have a second?
Second. Lisa Carter, second the motion.
Any other discussion? All those in favor say aye.
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 Any opposed? All right, we'll move to go into executive session on the phone number provided. Everybody have it? Don't email David. All righty, gang. See you in a minute.
Are we live? Are we live?
Okay, we're getting there. When I look at myself in the camera and the seal is behind me, it looks like a Grecian hairdo or something. Big. Yeah.
Deb, before we begin, I've got one housekeeping item. If you have
Okay,
some,
go ahead.
just wanted to mention earlier for the record that one of the BSRB staff, Sammy Barksdale, was able to sit in on part of the meeting, so she was in attendance. So we want to go ahead and mention that so that we can note that in the record for the minutes.
Great, thank you. All right, well, we are gathered back together and we can continue with the agenda with the meeting schedule. But before we get into that and why I'm potentially offering to change it, if we could have our representative attorney, Jan Art, speak to the role of the advisory committee and CAPA sessions.
As we stated before, CAPA has like specific language about who can make decisions and handle cases, whether it's an application or discipline case. And what they're really talking about, like for the initial part of it, are people are called presiding officers. And the definition of presiding officers are the board members. And so only the board members can be a presiding officer. The advisory committee members that are not board members cannot be a presiding officers. So consequently, that's why you don't have the advisory committee for the complaint review committee for discipline cases. It's all board members. It's the same thing for the for your committee or for any of the advisory committees. You don't qualify as a presiding officer. So consequently, you're not going to be sent applications. And the reason, so to help you decide whether or not someone is qualified to be licensed, the reason for that is if the board, because there are board members, at least one on every advisory committee. If they were to have discussions with you about applications, then that becomes the ex parte that we discussed during the training. So consequently, that would, disqualify them. So we want to keep as many board members, as possible to be presiding members. There could also be some confidential information. So this protects you from not receiving anything that would be confidential that you should not be receiving. So for that reason, that's why you don't really have any say in applications or in the discipline cases. Does that help or not? Want any more explanation?
I mean, it all sounds perfectly reasonable. Do you want to talk about the ways that a person, someone outside of the board could participate in some sort of advice? I think it's through contracts set up.
Yeah, just last week, the board did decided to go with expert witness contracts so that if they do need help determining the qualifications, typically these are for people who go to schools who are not accredited is usually where this comes into being, or in discipline cases, it may be an issue of the scope of practice or if it was incompetent. A board member should not be sitting as a witness. So by actually going through and making some of those determinations, if there was ever a hearing, someone could say, okay, I want the board member who made this determination that my education wasn't sufficient or that I was incompetent. I'm going to call them as a witness so I can cross-examine them. And that's not the member. We said that the enabling acts determines what the roles are for the board members, and being a witness in a hearing is not one of them. So this protects the board members then from having to either have ex parte communications or serving as a witness in a matter. So that basically we're going to start relying on expert witnesses to help us with those decisions where we feel that an expert witness may be necessary if it would go to hearing so that we can call them in to give that testimony. If that helps explain sort of what's happened.
Everybody understand? Any questions? Okay. So I part of the reason that we held to a fairly aggressive meeting schedule has been to deal with those CAPA applications in the past so that they could be put before the board in a timely manner. So I guess I'm kind of offering to meet quarterly going forward. We can always have a meeting if we need, to have some conversation about something that's come before the board. But any thoughts?
I think quarterly sounds good. I think you're right. We wouldn't have as much pressing issue. Obviously, if there was something we were working on that did need something acted on more quickly, then we could schedule differently if needed, right?
Yep. Okay. Any other thoughts?
This is Jason. I'm fine with that. I think it's a fine idea. Fewer meetings is always better, in my opinion.
Definitely. I definitely don't agree to meet just for the sake of meeting. Okay. So it change up a little bit what months we meet to actually do it quarterly. So it'll be March, June, September, and December. I like some of this because I think maybe 3 of those are all board meeting months. And I think the information in the board meetings is going to be a little fresher for me, to be honest, as I come to meet with you guys. So maybe that'll help me. So do those dates work for folks? June 8th. So do we want to stay 11 to 1? Is that what people like? Still on Friday, third Friday, just change the months.
Yep.
June, September, December. I will send that out to this group because I had canceled the meetings, so I will get it changed. And you'll get an outlook. Everything else will stay the same. Sound good? The last thing I had was just, and I had put it in an email, I think that I did find out that according to the governance policy, you can only serve 4 2-year terms, which is interesting because it kind of coincides with the board members serve 2 4-year terms. So it all kind of evens out in the wash, presumably. I think, well, I had Leslie check the start dates of everyone, and we've had a lot of new members, so that really helps. I think we only have one person that might have been on as long as 8 years, which would be Kendall, because he started when I did, I think. So I need to get with him. Otherwise, you can just kind of add, actually you'll want to just add 7 years to your start date because you kind of count that partial year, right? So you start the partial year you started and the partial year of ending. We'll assume it's fiscal year, state fiscal year.
So do we have some document somewhere that says when we started? Because I got no idea.
Yeah, well, Leslie looked it up. So Jason, I'll just tell everybody, Jason, you're 2016. So you're the next old person. Maybe.
Unfortunately, you're not the first one to say that out loud. So I guess I won't take
Maybe
offense.
experienced is a better word.
Experienced,
The chopping block.
wise old sage you are. I'm still older than you anyway, so I can give you all the grief I want.
I can always hang my hat on that, Deb.
Jane and Justin started in 2017. Dulce 2018, Mike 2019, Sana and Christina, of course, in 20. So, Jason, you'll be happy to know you're rolling off about the time that my term as a board member ends. So, after quite some time with the
We'll
BSRB.
go off in a blaze of glory.
Yes, I will, of course. What other way is there? Okay, that's all I had for today. Do I hear a motion to adjourn?
This is Dulcinea Rakestraw, and I move to adjourn.
Second?
This is Christine and I second.
All right. All in favor, say aye.
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 Bye.
Aye.
All right, gang. Have
See
a
ya.
great weekend.
You
And
too.
I'll see you in June. Bye.